Good morning, folks. Happy Wednesday. Hope everybody's having a good day so far. We are coming live to you with an update on the exciting form changes to the Texas Real Estate Commission contracts. We're going to get started here in a minute. It's 10 o'clock right now, so we're going to give folks, a couple minutes here to continue logging on. And we'll start here in a couple of minutes by allowing our sponsors to say a brief word about them, and want to thank them for coordinating this event. So far, it seems like a very well timed event. We've had, I think, over 500 registrations for the event, so there seems like there's a good amount of interest in it. So I wanted to thank the sponsors for putting this event together and bringing this to you. At this point, I'm going to turn it over to Britt Naponic with Bespoke Title and ask her to do a little intro for her company and say whatever she wants to say. So at this point, I'm going to turn it over to Britt. Thank you, Britt.
Thank you, Bo. Good morning to everybody. I'm used to speaking in person with everybody. I wish we could all be together, but I'm thrilled that we're able to offer this right after the first of the year. It's a great opportunity to refresh yourself about everything you're going to need going into the new year. I am the Senior Vice President and General Counsel of Bespoke Title, and I've been a licensed attorney for 16 years, 15 years in the title industry. Obviously, I'm still very passionate about it, and I worked with Old Republic Title for 12 years, managing claims and corporate litigation, and then at Stewart for 3 years, working with their national direct operations. So working with a family of independent agencies is different for me, and I'm thrilled to be a part of it. I joined Bespoke in October of last year, and Bespoke is our management company, which provides a collaborative team and shared resources for all of our independent agents across the state. So while each is independently owned, they're all supported by the Bespoke team. I think what makes us different is that we truly understand that every market is different and unique, and we really are custom tailored to serve the specific needs of each market. Very, very proud of our team, and we're so excited to have the opportunity to partner with all of you in your practice. So tomorrow I will be teaching a class on the top 10. That's just the catchy name for it, but it really just gives you the background of exactly what you need to know as we partner for all of our closings in the coming weeks and months. It's a great time to do it. So I look forward to being with you tomorrow, and I'll toss it back to Bo.
Britt, are we going to circulate through the chat a sign up for your class tomorrow? Probably a good idea to do so if we can.
Yes, and it's a great class because it's not a full hour of teaching. It'll be about 30 minutes, and then we'll have time for discussion and questions, and so it'll be great.
Outstanding. Well, Britt, thank you for sponsoring this event and for everything you guys do. Just to be clear, that the Bespoke, people may not be familiar with Bespoke. If you want to reference the actual title companies that people might be more familiar with,
right.
I think most of our attendees are coming from San Antonio, Corpus, Lubbock, Midland, Amarillo, and El Paso.
Well, we have our West Texas team at Joy and Lubbock, and Tall City and Midland, and Lighthouse and Amarillo, Gateway in Laredo, and obviously just opened in Corpus in November, and then our wonderful operations with Key Title Group in Austin and San Antonio. And we are growing. We're really, really excited about it.
Thank you, Britt. Today we'll be going over some changes to the TREC forms. Like I said, myself, Lisa, and Garrett will lead the conversation on that. Then at the end, which we're going to try to wrap up around 11, pretty close to 11. We'll open it up for some questions. Danii will lead us through some questions at the end. If you have questions, please chat them, and Danii will be following the questions as we go, and then she'll present 2 or 3 or 4 or 5 at the end, and we'll answer your questions at the end. So feel free to use the chat function. Here's what we're going to go over today is like I said, the TREC changes that are coming. We're going to go over and explain those changes. We're also going to give you a little background into the why of the changes. I'll probably cover that part since I'm on the committee, so I can cover that. We're also the main changes there's 2 main changes we're going to address. Number 1 is the changes to the earnest money and option fee, the practice around that. The second one we'll go over deals with leases and what we've done to the forms as it relates to leases. The next thing is, there's a couple of new addenda that we created. We'll go over that as well. And then at the end, we'll talk about Seller Shield is another sponsor to what we're doing today. So with that said, let me start on the when part. When is this going to go into effect? The forms are currently on the TREC website with a couple of exceptions. Not all of them are available. They're published on the website, but they were not mandatory for use until April 1. So the when will you need to understand these forms and start using them? They will become mandatory on April 1. TREC has not finally approved a couple of forms. I think the buyer's termination and the short sale addendum have not been formally approved by the commission. That's going to happen, and we think that's going to happen in their February meeting, which is, I believe, on February 16th. After that happens, all of the forms will be published and available for voluntary use in mid-February. So you can start using them voluntarily. You don't have to in February and March, and it becomes mandatory on April 1. So we got a little bit of time to get used to these forms, understand the changes we've made, and get ourselves familiarized. So that's the when. Now is the what. What did we actually change? There are 7 forms that we have modified and changed, and then we created 2 new forms. And then you can see the 7 that we changed and the 2 new ones here on this slide. The unimproved contract, the 1 to 4 family, 2 new home contracts, farm and ranch contract, the residential condo, and then the addendum for the POAs. Those are the ones that we have changed. The 2 new ones that we created are the 2 ones for the addenda regarding residential leases and addenda for fixture leases. So we've got the when, April 1. The what are these 7 forms that we've changed and the 2 new forms that we've created. Just as a note for all the attendees, we are going to chat a link to this PowerPoint and also a link to a PDF that has this presentation in it, and you can download the PowerPoint or you can download the PDF. And if you download this PowerPoint, it will have a link to the forms on the TREC website, so you can link directly to the website to get the forms. If you download the PDF, you'll be able to get the forms through the PDF we put on the chat here in a few minutes. Okay, with that said, let's now move on to the why. We've got the when, the what, and the why. The main change, at least for me, I think the main change is to the earnest money and the option fee. The impetus for that change is TLTA. And I guess I should probably back up. I think a lot of you know this, but probably not everyone. I serve on what's called the Broker Lawyer Committee at TREC. Our committee is responsible for all of the forms that you guys are required, all the TREC promulgated forms that you guys are required to use. My committee is the one that drafts those forms and creates new forms. I think most of y'all know this, but the committee is made up of 6 lawyers throughout the state of Texas, and I'm one of the lawyer members. And then we also have 6 brokers who serve on the committee as well, and then we have 1 at-large seat. We meet periodically to address market trends that we might need to make a change for. We meet pretty much every year in June when the legislators are in session to make sure that we adopt any particular legal changes to the flow in the forms. So that's a little bit about our committee. So the why. Why did we change the earnest money and option fee? Well, TLTA came to us and asked us to change it because their position is that it is that a lot of their member title companies are experiencing agents bringing the option fee directly to the title company as opposed to delivering it to the seller. And they said, look, I know you guys think practice should be that it's delivered to the seller, but the reality is the agents are delivering it to us and asking us to deal with this. And they said, why don't y'all change the forms to match the way it's actually happening in practice? That's what happened, and that's why we made the change. The other big change that you're going to see is related to leases. And the reason that we changed the forms to address leases is leases and issues surrounding leases are getting more and more complicated. And for instance, there's software and hardware now that is leased in a more frequent basis. Think advanced, audio visual components in a home. Think security systems. Think water filtration systems, all sorts of things now that are revolving around leases. That is a relatively new phenomenon, and we've updated the form with that. And then finally, we just did a standard cleanup. What we try to do on the committee is not change the form too frequently, because if we change them too frequently, you guys will revolt and you will hate us. So we try not to change them too frequently. So we do what we call just kind of a wish list or a cleanup list that we keep, and we don't implement little minor changes to the form. For instance, we changed the notice section to add more ability to list.
That's okay. The right time will happen. So
as opposed to facts. So that's one of the things that we do, just sort of a standard cleanup. So that's the why. Now let's move on and talk about the earnest money and option fee. And Lisa and I are going to tag team this one. Lisa, before I sort of jump into the weed here on the actual changes, I'd love to get some perspective from you as a practitioner and somebody who deals with contracts on a day-to-day basis from a broker's perspective. Do you want to add anything to the earnest money and option fee changes before we dig in to the actual nitty-gritty?
Well, thank you both for having me on, but I do want to kind of expound on what you said about it's just high time, because there was a lot of delivery to the title companies with the option money, and they would accept it but mail it out, and it was not a timely delivery per contract for the buyer to be protected and have an option period. So it was happening so much, it was just a nightmare. And I think this is a great move, and I'm very excited to see this, this one part for sure.
Excellent. Yeah, I agree. I had some of the members of the committee had some concerns about this one, and I'm one of them. But I think it's going to be great. I think it was overwhelmingly the response we got. I got stuck in one place there. The response that we received from the real estate community was overwhelmingly positive.
Right.
That they wanted this change. So I think this is one that's going to be popular.
And I really think it takes the pressure off the title companies too for accepting and it being legitimately accepting it now, rather than as a good title company and helpful in marketing and wanting to be helpful to the agent. Now it's official and legit. So that's a weight off everybody's back, I think.
I think so. Let's fingers crossed. Let's hope it works out.
Yeah.
We did create, I think, some potential for harm and error, and that's one of the big things I wanted to point out as a practitioner's point when we go through here. But Lisa, I'm going to dig in. You feel free to chime in here as we go through the actual changes. This is taken from the form as it is right now in the 1 to 4 family. I'm sorry, as it is proposed to be, misspoke, as it is proposed to be, and likely will be mandatory on April 1. So this is what it's going to be, not the way it currently is. All right. With that said, this will be in paragraph 5, which is now dealing with earnest money and the option fee together. As you know, it used to be the earnest money and the option fee were in separate paragraphs. Earnest was in paragraph 5. Option was, I believe, in paragraph 23. Now, the earnest money and the option fee are going to be in one paragraph. Everything related to that will be in one paragraph, and it's going to be paragraph 5. So that's the first sort of big change you'll see in the new forms. So let's dig in here and go over some of the key points that I think are going to be important in dealing with the option fee, the changes to the option fee. So starting off, let's talk about when. Delivery of earnest money and option fee must be done within 3 days after the effective date. Buyer must, and must means have to, they shall, buyer must deliver to escrow agent. So if you're thinking, well, can I still deliver the money to the seller? The answer is no. Buyer must deliver to escrow agent. And then we've got a blank for the earnest money and a blank for the option fee. So there's 2 blanks that you'll, if you're presenting an offer, that you'll need to fill in. The earnest money and the option fee, separate blanks. That's the first sort of thing that has me a little bit worried. But hopefully we'll get this done. So that's who you deliver it to and when. It's got to be within 3 days, and it's got to be delivered to the escrow agent. So let's move on. The earnest money and option fee shall, so again, that's mandatory. It has to be made payable to escrow agent. So not the seller anymore. If you're writing a check to the option fee, it's made payable to escrow agent, and it may be paid separately. So in other words, if you're advising your seller on how to write the check, they can write 2 checks. They can write 1 check for the earnest money and 1 check for the option fee, or they can combine it in 1 single payment. So let's do a hypothetical here. The hypothetical is you're presenting an offer to a seller, and you want the earnest money to be $10,000 and you want the option fee to be $100. Your buyer would have the option to write 1 check and the amount of $10,100 payable to the escrow agent, or they could write 2 checks. The first check in the amount of $10,000 for the earnest money, and then 1 check, a separate check for $100 for the option fee. So,
Bo, can I chime in on that just a little bit?
Of course, please.
Both, of course, are good, are fine, but I just got to think about this, and I was talking with Garrett about it. If it's in, I prefer 2 separate ones. A couple of reasons. One, addition is not some people's strong suit, so and I'm going to be included in that too. And so if you're writing that $10,100 check, if you accidentally write it for $10,010 or whatever you add wrong, of course, as we go on, the option money will be taken out first, so you're going to be short on earnest money. Secondly, a lot of times when the option fees sit back, the lender will look to see if there was a $100 deposit or clearing before they will allow the option money to come back. So it's very clear that if you write a check for $10,000 for earnest money on 123 Main Street, or you write an option check for $100 on 123 Main Street, it's very clear. And as far as when you're banking and any kind of lending issues, but it just is, it makes it more. That's just my opinion. Both are fine, but that's just my preference. Kind of just I got to thinking, hypothetically, what could happen if you wrote it in 1 rather than 2.
I think that's great advice, and it fits nicely into one of the practice tips I'm going to elaborate on here in a minute. So I love that, and it makes total sense to me. So good practice tip, Lisa. Write 2 checks makes good sense. You don't have to, but I think it makes good sense. Right. So let's move on here to how do you calculate the 3 days? That's a common question we get on the committee is how do you calculate these things? So the main thing that I think causes confusion is what happens if the 3rd day falls on a Saturday, Sunday, or a legal holiday. Is it due then? Am I going to have to be tracking down the escrow agent on the weekends or holidays to get them to accept the option fee so that my client has an option fee? The short answer is no. But let's go through this section 2 here and explain why the short answer is no. If, and then what we're talking about here is if the last day to deliver, if the third day falls on a Saturday, Sunday, or legal holiday. So I'm going to read this. If the last day to deliver the earnest money option fee or the additional earnest money falls on a Saturday, Sunday, or legal holiday, the time to deliver the earnest money option fee or additional earnest money is extended until the end of the next day that is not a Saturday, Sunday, or legal holiday. So let's do an example here. So if day 3 falls on a Sunday, then the option money and earnest money would not be due that Sunday. It would be due the following day at the end of the day on Monday, unless Monday is a legal holiday. If Monday is a legal holiday, then the time period would be extended to Tuesday at the end of the day. So I'm going to stop right there. Lisa, does that make sense to you?
It does. Yes. And that's kind of a gift for the change, is a gift for the option fee, because you're not scrambling around on Christmas Eve to deliver an option fee because it's the third day and you didn't have that that trait that it is now. So that's exactly how I see it.
Yeah,
Yes.
and I think that's nice. That was one of the compliments we got, is you're not having to mess with that stuff on the weekends or holidays. So
Right. Oh, I mean, agents would be in panic modes. They'd just be going, "Oh my gosh, it's Christmas Eve. I can't get a hold of the seller's agent or anybody, and what am I going to do?" So
Yeah.
This is great. Yeah.
I think so too. Then the third section here kind of deals with something Lisa alluded to. If there's one check and it's not for the right amount, then how the escrow agent will apply the money, the order that it will be applied to is the option fee will be applied first, then the earnest money. So like if Lisa said, if there's some kind of shortage, you could be in a situation where the option fee is covered, but the earnest money is not covered, and you might be stuck in a position of having a issue there with the seller being able to terminate. So obviously, if you're going to write one check, as Lisa said, make sure it's for the right amount. All right. Finally, number 4, buyer authorizes escrow agent to release and deliver the option fee to seller at any time and without further notice to or consent from buyer, and releases escrow agent from liability for delivery of the option fee to the seller. Okay, let me give you a little background in here. One of the objections to doing this change, to changing from delivery from the seller to the escrow agent, was that frankly, title companies have not done a good job of dispersing earnest money when there's some kind of dispute between the buyer and the seller. There was a lot of complaints made in our committee of instances where a title company wouldn't release earnest money when they probably should have, and they required the buyer and the seller to agree, which put one of the parties could game the system and the title company wouldn't act. So one of the objections to taking this and giving the title company more power by holding more money was, look, they're already doing a bad job of dispersing earnest money when they should. We want to give them the ability to deal with more money. So we put this sentence in to hopefully make it crystal clear that the title company, once they get the option money, it's not theirs. They are literally holding it for the seller. It is the seller's, and all the seller has to do, literally the only thing the seller has to do is ask for it. And they can ask for it at any time. The title company could get it on a Monday, and the seller could say, that's my $100 and I want it right now. Now, the title company can, and they absolutely have the right to verify that the $100 is in good funds. Mm-hmm. So if they get a check, they have within their power to wait and make sure that it is good funds before they give it to the seller. But once the seller asks for it, that is the only thing that the title company can hold on, is verifying good funds. Yeah. Once they've verified it's good funds, it is the seller's money, and they could get it at any time. So that's why we put in paragraph 4, is to address that concern.
Bo, can I just mention one thing? I see a lot of chat popping up on the deadline on that third day to deliver the option money. It is not a 5 p.m. deadline.
Right.
A lot of people get confused on that. Now, the title, I mean, I've had title companies come to someone's house at 10:30 at night, receive a contract with with earnest money. So as long as it's not a 5 p.m. deadline, many people confuse that with the deadline to terminate the option period on that day. Just FYI.
Great clarification. I meant to say that, so thanks for covering that. Absolutely. As far as I know, the only 5 p.m. deadline in any of our forms is to terminate the option period.
Yes.
Everything else that has a day deadline is the end of the day. So good clarification, Lisa. All right, let's a couple more points on the option fee.
Can I go back to one more thing? Didn't, Bo, correct me if I'm wrong, but didn't the last sentence, the option fee will be credited to the sales price at closing? Isn't that a change where you don't have a choice anymore? It will automatically, if you close, you're getting your option money back. I just noticed that when I was reading this morning that there's no selection. It is going to be delivered back to them, which is one of the things. Make sure, you know, if that's going to happen, that buyer cashes, that seller, excuse me, cashes that option fee, because that could be a problem in closing, because you have to verify that it's cleared before the lender will allow it to be refunded. So just
no, great point.
Comment.
Another good catch. Thank you, Lisa.
Thank you.
Perfect. All right. Anything else on this one, Lisa? Or,
I think that covers that. That's great.
Excellent. All right. So some final points here on the option fee. In paragraph D is what I wanted to call out. Failure to timely deliver the option fee. So there's two potential hypotheticals in paragraph D here. Number one is if no dollar amount is stated as the option fee, then there's no option fee. I assume that's kind of obvious. But what I could see, back to people having issues with math, me included, I could see an agent writing in under my hypothetical of 10,000 for the earnest money and 100 for the option fee. I could see an agent get going fast and write in 10,100 for earnest, and in their mind they thought, well, I've got 10,000 for the earnest, 100 for the option, I'm good. If you do that, your buyer will not have an option period. So if hypothetical number one is if no amount is stated as the option fee, well, then there's not going to be an option period and your buyer won't have that. The second hypothetical is you put in the amount, but the money doesn't get delivered to the escrow agent in a timely manner. So let's say you put in $100, you got 3 days, and for whatever reason, the money doesn't get delivered within the 3 days. Well, under both of those hypotheticals, the buyer will not have an option period. So it's very important that we make sure we get that right, because for me, and I'm going to get to this in a second with the practice tip, I think most of y'all know me, but probably some of you don't. I have spent my career defending real estate agents and real estate brokers in lawsuits and things like that. One of the most important tools I have in defending real estate agents and brokers is the ability for the buyer to do due diligence. I get to stand up and get to say, ladies and gentlemen, the buyer's upset about this, but they really should, the only person they should be mad at is themselves. In Texas, we believe in things like due diligence. We believe in things like protecting ourselves. And we give the buyer an opportunity to do that in the state of Texas, and it's called the option period. So it is a critical component to almost every time I get up in front of a judge or a jury and make an argument that a real estate agent shouldn't be responsible for something. So it's really important to me to protect you that we have option periods for buyers. So this is a really important point to me. Finally, time is of the essence for this paragraph, which means that it is a hard actual deadline. So, and I know this is confusing. I promise you, this is confusing to everybody, even the people on our committee. This is one of the issues the lawyers will argue back and forth on. But time is of the essence means it is an actual enforceable deadline. That if you are 1 minute late, too bad. You've lost your rights. It is an actual hard deadline. So if you've got that crazy scenario where your title company will, for whatever reason, come to you at 12:30, which was technically on 12:30 a.m., which is technically the beginning of day 4. You've missed your deadline, and the buyer may not have an option period. So hard deadline. Make sure you get it on time. Okay.
Bo, can I ask you a question? That being said, let's say that the option period is delivered after the deadline, and the title company escrow agent sends it anyway to the buyer, and the buyer accepts it. Is that accepting? In other words, are they giving them the right for termination, or are they just, is that just?
I presume you mean the escrow agent gives it to the seller.
I'm sorry, to the seller. Excuse me.
No worries. I knew what you mean.
And the seller accepts it. Does that basically say, I'm giving you your option period, or are they just saying, too bad, I get $100 and you don't have that right to terminate?
Good question, and this is one of those reasons that people hate lawyers. The answer is it depends. Depends on all the circumstances, right? I mean, probably that is the likely outcome, but it's not like a for sure thing is the outcome. It's the likely outcome. What I would tell you is if you find yourself in that scenario, I would do an amendment and make it crystal clear that there's an option.
Yeah. Okay.
Both there's an option period that both parties have signed off on. That's what I would do.
Yeah.
But
okay.
Are you probably right, Lisa? If the seller accepts the $100, that the buyer probably has an option period. That is probably correct, but not for everything, because this paragraph is crystal clear. Time is of the essence, and you lose your right if you don't perform.
It's kind of like the earnest money. If you don't deliver it in a timely manner, but you deliver it, and the seller accepts it before they do anything to exercise their options on, like paragraph 15, or terminate, then it's all bets are off. They've got to act before that. I was just kind of equating it to that.
It's similar to that, absolutely. Okay, I'm going to move on to some practice tips, which I've already hit on one of them. Practice tip number 1: if you're representing a buyer, please don't get caught without an option period because you make a mistake and write in 10,100 for your money. Or if you're intending to have an option period and you just forget to write in the amount, please make sure that you don't get yourself in that position, because it is if you're stepping back for a second and you're thinking about real estate transactions in the state of Texas in a really high level, like a 30,000, 100,000 foot level, if you really think about how the transaction is supposed to work, it's supposed to work where a buyer gets to see the property a little bit before they commit to buy it. And then we give them a time period to do due diligence so they can confirm that the property is what they thought it was, what they think it's going to be. And at that point, that they can make an intelligent decision about buying the property. It is a critical point in the real estate transactions in the state of Texas. So just please preserve that. And along those same lines, please explain that to your buyers. If you're representing a buyer, please continue to explain the purpose of the option period. I'm a little worried that we had a separate paragraph for the option period, paragraph 23. And it would be really hard to kind of miss that. I'm a little worried that we kind of buried the meaning of the option period now into paragraph 5, and that agents may not explain it like they used to when it was a separate paragraph. So please explain the purpose of the option period to your buyers, because it's critically important for people like me to defend you guys when there's a claim. Okay, Lisa, any final thoughts on that?
I think that covers it. Thanks very much. And I think those are some great changes. And as always, I tell everybody, please read the verbiage, read it, because it literally, if you read it, it makes much more sense. Even if you don't have something to fill in, a blank to fill in, make sure you understand the other comments or the other points on those paragraphs, because it'll make your life much easier.
Cool. Well said. Agreed. Okay. Major changes are here on this page. We're going to go, Garrett and I are going to go over a few of these, but in particular, we're going to focus on paragraph 4, dealing with leases. Then Garrett is going to go over paragraph 10, which is smart devices. And we've already covered paragraph 23, which is what the option period used to be and now has been deleted. So we're going to focus now on paragraph 4 and paragraph 10. And also there are 2 new forms that we drafted for residential leases, an addendum regarding residential leases and then an addendum regarding fixture leases. And we're going to pivot and we're going to get into that now. So with that said, Garrett, I'm going to pivot to you and let you take the ball here on leases because you're actually way more knowledgeable on this area than I am. So kicking it off to you.
Thank you very much, Bo. Well, welcome everyone. Garret Brandt. For those that may not know me, I'm in-house counsel at Keller Williams Heritage here in San Antonio, and I deal with this stuff all the time. So this is, they took paragraph 4, and if you remember your contract, or if you know it well, paragraph 4 used to be where you had a disclosure that you were related to one of the parties, or you, one of the parties held a license, real estate license. They moved that to paragraph 8, minor change. They just moved the place of it. So it freed up paragraph 4 to deal with leases. And leases have become a really exponential issue with the number of investors owning properties with residential leases and the number of new technology and existing items that were on fixture leases. So it really became an issue that needed to be dealt with, and that's what they did here. First of all, they took some of the language out of paragraph 10B, where it said that the seller is not aware of any leases and they may not enter into any new leases or extend any leases once the contract is signed. So that's the same language, it just moved into here. But then they added a few other subparagraphs. It says that the seller is not aware of any leases except as disclosed inside this contract now. And we're going to deal generally with 3 areas of leases. You have the residential lease, which is your typical tenant occupying a residential property. You have a fixture lease, and this is items that normally would be conveyed with the property. They are fixed to the property. They are fixtures. They are attached. Seller can't take them with them, but in this case, the seller doesn't own them. There are some very common ones that you're going to see when we get to the addendum: solar panels, and security systems, water softener, propane tanks, and there could be others that come up in various residential situations. And the third type of lease would be leases of natural resources. So the first 2 that we talked about, residential lease and fixture leases, have brand new addenda that are going to go into much greater detail. I'm going to get to those in a second. The leases of natural resources doesn't have its own addenda, so you are going to need to pay attention to this and have the seller ask the seller if there are any natural resource leases that affect the property, and that then the buyer has a right to terminate the contract with the number of days specified. Now, this is only if the seller is a party to that natural resource, like they've entered into that lease themselves and therefore have a copy of it. If they purchase the property with the natural resource lease already in place, they probably don't have a copy of that lease. They can't pass it on. Buyer can't terminate. Seller doesn't have any control in that situation to pass that on. So what are natural resource leases? Could be wind leases. You typically think oil and gas lease. That's one of the most common. But it could also be timber leases. Anything that uses the natural resources where a third party has the right to utilize the land for those purposes is a natural resource lease. So we are talking about, in this context, the 1 to 4 single family residence. Hard to imagine in many subdivisions you're going to have wind leases or oil and gas leases, so it's not going to come up much. But imagine a more rural setting with 5 to 10 acre tracts of land. There could be these leases that affect that. So it's still important to know about this. This is a change in the 1 to 4. They made similar changes in all the other contracts, your unimproved property contracts, your condo contracts, new home construction, and farm and ranch. But there are slight differences that you're going to encounter in all of these. Like in the condominium contract, they do not have a natural resource lease section in your condominium contract because you can't exactly imagine a wind farm in a condo. I mean, you can imagine it, but it's very unlikely. So and like on the unimproved property contract, there is not a residential lease section in the unimproved property contract because there shouldn't be any occupants, any tenants, residential tenants on unimproved property. So you'll see the changes are consistent, but just know we're talking here about the 1 to 4 contract. So we have 2 brand new addenda that when these leases exist, residential lease and or fixture lease, you must include the addenda. These are not optional. These are not something that you maybe want to add. No, if these exist, you need to do that. So if I can get the next slide up, please, Bo, we're going to get to the first of the new forms, the residential lease.
Yeah, Garrett, can I chime in just briefly?
Please.
I like to think about this provision is you have buckets, if you will, and the default bucket or the default position regarding leases is the first one here, and that is that the seller is not aware of any leases, and that they're making a representation to the buyer of 2 things. Number one, I, as the seller, am not aware of any leases. So that's an actual representation that the seller is making to the buyer. I'm not aware. And then the second representation is I'm not going to enter into any written leases once we have a contract up until closing. So that's sort of the default position that, frankly, most contracts are going to fall into. Yeah. So that's, like I said, that's default. Then we've broken out 3 alternative positions or 3 separate buckets, if you think about it that way, to where if there are some leases, then you obviously the seller can't represent that they're not aware of any because they obviously are. So the 3 other options, big high level, is residential leases, fixture leases, and natural resource leases. So if you're from a practitioner standpoint, if you're preparing an offer, or if you're a seller and you're replying to one, you should fall into one of those 4 buckets. Number 1, don't have any leases, not going to enter into any. Number 2, I do have a residential lease, so I need to give the buyer some information about that. Number 3, I have a fixture lease, so I need to give the buyer some information about that. And then number 4, we have a natural resources lease, so we need to give the buyer some information about that. That's how, in my sort of simplistic mind, I look at this provision as how it's set up.
Yeah.
Next slide.
Yeah, next slide. So I'm looking in the chat, and one of the things about this is just buyer's agents are going to have to ask more questions. But a practice tip here, when you're taking a listing, you need to be asking your seller a lot more questions about fixtures on the property. Obviously, if it's an investment property and there are tenants, they're going to tell you up front that there are, hopefully they'll tell you up front that there are residential leases or a residential lease in place, but you're going to need to probe a little deeper about other leases on fixtures. Okay, but let's talk about the residential lease aspect. So this is a brand new addendum. It's been adopted and will become available for use when they finish publishing the rest of the documents in February. February 16th is a TREC commissioner meeting, and they're going to approve these for voluntary use starting probably right thereafter, and that's when they will first become available, and then mandatory on April 1, as we've been saying. So this new addendum, if there's 1 or more residential leases on the property, you have to include this form. It gives the buyer 2 options in this, since the buyer is filling this out. The first is that they could ask the seller to have all residential leases terminated by the closing date. If maybe the buyer wants to take an investment property and either fix it up to flip it or live in it themselves, and they don't want the tenants to have to deal with getting the tenants out. So they could ask the seller to terminate the leases. That's option 1. I know the picture is really small. You don't see that, but it's there. Option 1 is to just have the seller terminate all leases. As a practice pointer here, this could be very expensive for a seller. They may have to buy out a lease to agree to this. It could delay closing if the tenant doesn't vacate on time. Now, let's be clear, the form says the seller will terminate the lease. It has it doesn't say anything about the tenant vacating, which could be a problem. There's somewhat of a conflict there. We all know instances where a tenant has lost the lease, but they refuse to move, especially in this strange age of pandemic. It's hard to evict a tenant who just willfully stays over. So you've got to work through this. You're going to represent a buyer. You're going to want to ask a lot of questions. You're going to want to really make sure that the seller can not only terminate the lease timely, but is in a position to make sure that the tenant will vacate as well. Assuming that the buyer wants to keep some of the leases that are in place, the second option would be that they're going to be assigned and assume the obligations of landlord and take the leases over. So here it says that the copies of leases will be delivered to the buyer within 7 days. And then it covers that the security deposit will be transferred to the buyer at closing. Now, this is already in your contract, in the existing contract, paragraph 9B5 covers transfer security deposit. So this is not a change. It's just now found in a different location of the contract. So that process will be the same. The one difference that's in here that is brand new and is going to catch many sellers by surprise. The last part of this says that the seller makes certain statements to the buyer. These are not representations. That word was originally put in there, but then was removed. These are not seller representations. So if the seller isn't honest about this or forgets something, they're not in breach of a representation. So the measure of damages will be little, but they're making statements about the leases to the buyer, saying that they're in full force and effect. There's no defaults. There's a list of about 8 items that the seller is saying, to my knowledge, this is true about these leases. And then there's a continuing duty on behalf of the seller to update the buyer should any of these statements change. Like if the seller says the tenant is not in default and then the tenant becomes in default on the lease, the seller has to notify the buyer. They have a continuing obligation to notify the buyer. And then if they do change, the buyer can actually terminate the contract. So this is something you on the listing side are going to want to go through with the seller very, very carefully and make sure they can make these statements, that they are true and correct statements, and then let them know that if anything changes, they've got to immediately tell the buyer, and we work with the buyer that they won't want to terminate. On the buyer side, you're going to want to look at those statements and then be aware that if things changes, you may have a right to terminate the contract based on that. So again, this is a new form. It's not a drastic change because it takes some of the same stuff out of the contract, but it's an important form to really work through. As we always say here in our office is to the agents, read the contract. Read it and know it, understand it. Don't just rely on the fact that there are blanks and you can't change anything, but read it and understand it, because the answers are in there. And I'm going to tell you the same thing that you can get usually by just reading the contract. So again, you can either ask that the leases be terminated, or you can assume the leases, and then there are certain provisions related to that.
Hey, Garrett, a couple of good questions that popped up on chat. Can I address those and then
please
move on to the next one? Number one is from Deborah Packer, I believe. Sorry, my vision's terrible. Deborah Packer, I think. She says, presenting an offer would be difficult to fill this in and get the offer executed at presentation. This is one more step. And she says, should we leave it blank and wait for a response? And I think that's the answer is, if you're representing a buyer and you're making an offer, the seller's probably, just by odds, is going to fall into the default position that they don't have a lease and they're not going to enter into a lease. So if you're presenting an offer, I think you should leave it blank. You shouldn't check paragraph B, which means that you're asking the seller to represent that there are no leases and that they're not going to enter into new leases. So yes, I would leave it blank unless you know that there is a lease on the property. And if you're making an offer and you know there is a lease, then you should check the appropriate box. Does that make sense, Garrett?
Definitely. But again, this gets back to asking good questions of the listing agent. Listing agents, maybe you want to put together an information sheet about the leases that your seller tells you about, upload it in additional documents in the MLS. Be proactive to work together to get the property sold and not have surprises at the end.
Absolutely. And then one more question, then we'll click on to the next addendum. This is from Kent Hebeson in Lubbock. Hey, Kent. Kent says, what is the actual point of this form? It seems unnecessary. Kent, I'll give you my 2 cents, and then Garrett, you chime in where you think necessary. I think the point of the form is to make the seller give an accurate representation of what type of leases they have. Then the buyer receives accurate information, and then the buyer is in a position to get out if they don't like the information they receive. Now, you may disagree on whether that's needed, and I may agree with you, by the way, but that's the point of the form, is to get the seller to accurately represent information to the buyer, and then put the buyer in a position of making an intelligent decision on whether or not they want the property. At a high level, that's the point.
Yeah, and I would also just add to that, it also helps prevent the need for additional language. If a buyer wants the current lease terminated, there was nothing else to do in the contract except write that language. And we all know that TREC doesn't want you writing anything in paragraph 11 if it can be helped. So they've created a form to minimize the need for termination of lease language or other representations or statements about the lease. So they've found a growing trend of agents negotiating these kind of termination provisions inside the contract and probably getting in a little bit of trouble over it too. So while you might find it a little overkill, unfortunately, we're going to be stuck with it, whether you like it or not. And that's just your government at work. So
does that make me part of the government? I don't like that if that's the answer.
No, you're outside of the government.
All right, good. All right, fair enough.
Next one.
Next one. Let me get to the next. Okay.
Yeah,
regarding fixture leases. You're up.
Yeah, the fixture leases. Again, this has really come about due to evolving technology. The evolving or the availability of a vast number of these kind of fixtures, specifically solar panels and security systems, water softeners, that have become available on the market under lease situations. And the contract would say that all of these are to be conveyed with the property. The problem is the seller doesn't own them. They're just a lessee, and so they may not have the right to convey them, or the buyer, in looking at this, might find that they have trouble with financing them. They're not going to be able to put them into the purchase price because it won't appraise and get those leases bought out. Maybe they don't have enough debt to income ratio left to take on $125 a month payment to continue the lease. So there's a lot of these issues that we're finding that are coming up. I like the fact that we have this form now just to highlight the issue, to bring this out in the open up front. I think in the last 12 months, we've had 5 or 6 deals, maybe even a couple more, blow up at the closing table because it was not really well disclosed that the solar panels or the water softener were on a lease. And they get to the closing table and the seller just assumed that the buyer was going to take it over. And the buyer's like, I had no idea. It's in the contract that you're going to convey these items to me. And we've had deals fall apart at the closing table over this. So if nothing else, this is going to raise the discussion right up front. Are these items owned or are they leased? So let's just talk about this form. You can see my notes. It's used only for leased fixtures. This does not cover fixtures that the seller has purchased but may owe money on. That's an entirely different issue. The seller does own those items. They just owe a bank loan on them or owe a financing company on those items, like solar panels. We have one right now where the seller is trying to sell the house and they own the panels, but they owe $18,000 on the solar panels. We can't, in this case, really lump, that's a sidebar. I was gonna say, we can't lump that in the purchase price, it won't appraise, but now we're getting off topic. So on the leases, had those solar panels been leased as opposed to owned, this form of lease is gonna bring that to the surface and we can have a conversation up front. So the buyer understands, what they're getting into. So as a practice pointer, when you go on a listing appointment and you go to a house and you see water softener, security system, propane tank, solar panels, it's a good idea to say, do you own these? Can you provide me documentation of ownership? Do you owe any money on these, or are they leased? We want to get paperwork. Not that you're going to read the paperwork and interpret it, but you can double check. We've had sellers that say, well, gee, I thought I owned it, and it turns out they're just being leased, or vice versa. They thought they were selling it on a lease, and it turns out it's really they're owning it. So you're going to want that paperwork to double check what the status of that is. And then it also bring up the situation, are there any other items in the home, any other fixtures that you also had installed on a loan or on a lease? So the form names 4 specific items, but it has a blank for any others because we don't know what the next big trend might be. It allows the buyer then to decide which of those fixture leases, if any, they want to assume. This can be one, if there are 3 fixture leases, the buyer may only want one of them. Maybe they only want the solar panels to continue. They don't care about the water softener and the propane tank. So you can specify which, if any, of the fixtures you want to continue the lease on as a buyer. But just because the buyer wants it, the seller may have trouble either assigning the lease. There could be fees for this. This is not as simple as just continuing the lease and switching the payments depending on the company and what's in those leases. So the seller's going to need to get their documents together and possibly get a good attorney to look it over and tell them what their rights are. I wouldn't trust, as much as I hate to say this, I wouldn't trust calling the company that sold you or leased you the equipment, because the salesperson on the other end may not be telling you the truth. They may not understand the ramifications. They don't know necessarily what's going on. So get someone to read your documents for you and give you an opinion on what your rights as a seller are to assign those. Or if the buyer doesn't want them, how do you get out of the lease? How do you end it? If there are 2 options. The seller either delivers copies of the leases up front with the contract, and then the buyer has them, or if the leases are going to be delivered a few days after that, the buyer actually has the right to look those over and terminate the contract. So you want to minimize that time for the seller by getting those leases up front. The last thing on this is that for any leases that are going to end, that the seller is going to make sure that they have to pay off any financing statements, make sure there aren't any liens, and repair any damage caused by removal. So just because a lease is ending, taking solar panels off a roof is not going to be pretty unless somebody's obligated to refix them, and that's going to be on the seller under this. So again, this is really necessary to raise the questions and walk through this. But it's going to catch a lot of people by surprise to really take time to read and understand this for each situation. Thoughts, Bo?
Yes. A bunch of good comments were coming in as you were going over that. One of them was Kent chimed in again, said he thinks this is a good form. Thank you, Kent, for solar panels. And this was one of the main reasons we did this particular form, is the proliferation of solar panels. So I agree, it's a good use for that. And then Garrett, I think you nailed it. It's you did a good job covering it. Garrett, we did get the same question about 5 times, so I wanted to go over that one. And the question is the addendum, and I'm going to go back here. Give me a second, guys. I'll go back to this addendum. The addendum regarding residential leases, is this applicable for a scenario where a seller has a short-term rental usage? In other words, a seller rents their property out on short-term basis as opposed to a longer-term lease. The short answer,
the Airbnb situation versus the long-term tenant.
You got it. I think, and I don't remember us actually discussing this on the committee, but I think the answer is yes. It could be, and it could be required to utilize in a scenario where you have a seller who is short-term rentals, and they've got rentals booked out into the future, where they've actually booked them, and they accept, or an offer is made to them. The question is, should a seller have to use the addendum regarding residential leases under that scenario? I think the answer is yes, they should. And if they accept the offer, they should stop doing rentals at that point. and address the situation with the buyer. However, under another scenario, let's say that you have a seller who has marketed their property on Airbnb, but they've got no actual response. Would that seller need to use the addendum regarding residential leases? I don't think so. But they would be at a point where they can't accept them after they accept the offer. Garrett, I hadn't thought about that before we got the question. Do you think that is right?
I hadn't thought about it either. I would actually be really concerned about trying to include short-term rental issues in this, because how do you deliver copies of the leases, security deposits, especially when they're held maybe through just a credit card, things. I'm not sure it's applicable, but that's really a great question that I hadn't even considered, because to me, Airbnb rentals are not necessarily residential leases. They're more akin to a hotel arrangement than a residential lease. But I understand the point. That is the right to occupy a residence exclusively under the terms of that lease. So that's a great open question. And this is why we have attorneys on different sides, because you and I came to different conclusions.
Exactly. That's what drives people crazy about us, is we could see the same issue and give a different answer. I would tell you that I think it does, because if you look at in the addendum regarding residential leases, the very first sentence is a definition of residential lease, and it means any lease of the property to a tenant, including any addendum, amendment, or move-in condition form.
Yeah. And that's probably a better, safer reading of it. And so when you're selling an investment property that it has Airbnb, err on the side of more information, more disclosure, more documentation. You'll be better off using it than not using it, because not using it could raise a question. Using it avoids the question altogether.
Yeah. That's good. I think that's well said. Okay, Garrett, unless you had anything else on that, I moved you on to paragraph 10, possession.
No, and this is great. And I'm going to have to get off right after this. I've got another class coming up. So a change in section 10. So section 10 is your provision on possession of the property, and possession either at the closing and funding, or subject to a short-term lease, or subject to an existing residential lease. They've added a new section dealing with smart devices. It's hard to occupy the entire property if there are smart devices on there, say thermostats and security devices and systems, in which another party has access and control over those devices through internet apps and other means. And so the committee has addressed that by putting in this provision. It's paragraph 10C, and it talks about smart devices. It's just a matter of keeping up with the changing technology. At the closing, and these are not items that are going away. These are items that are going to stay. The thermostat, the Ring doorbell, the security systems, the things that are on, but that you can control and access remotely over the internet is basically how it's defined. So the seller at the closing, or at part of the closing, must deliver to the buyer all access codes, passwords, etc., the ways to manage and control and operate those smart devices. As a practice pointer, and so the buyer is going to get all those to be able to learn how to do it. As a practice pointer, well, let me cover the last point first. Seller has a contractual obligation to then remove all of those controls from their computers, their smartphones, etc. It's an affirmative obligation of the seller to get rid of all of that. Now, how do you verify that, especially when you have a remote closing? The seller's already moved out of state. How do you check their phone to know that they've taken the Ring doorbell app off their phone? Well, it's hard to do that. There is a contractual obligation, but verification is going to be hard. So this gets to my main practice pointer of this. When you have a buyer and these access codes and passwords and accounts have been switched or given to the buyer, tell your buyer, go in immediately and change those codes. Don't just assume that the seller, because he's all good buddy and says he's going to do it, has actually done that. They may not keep it on there for nefarious reasons, but they may just keep it on there because they're lazy. Have your buyer change those access codes. We actually heard about a story, this just happened in the last year, about a buyer who purchased a home, had security cameras on it, and their backyard, the backyard of the buyer, was a very secluded backyard where it could not be easily looked into from neighboring roads or neighboring fences. It was very, very secluded. And one day, about a year after buying the house, they got an email from the prior owner, the seller, from a year earlier saying, "I love what you're doing in the backyard." Well, the only way they knew that is the seller was looking through the security camera through their app. They still had access to the security system in the house because it was never taken off and the buyer never thought to change the code. So while that may be harmless in the sense, man, that's creepy. I wouldn't want a prior seller looking at through my security cameras at all. So practice pointer on these systems. When you get the new codes, when you get these things, please immediately have the buyer change all the access codes. Any thoughts? Otherwise, I got to bag off and go do something.
Thank you so much. You've been great. Appreciate you. I know you got to go. I'll take the ball from here. Thanks, brother.
All right. Thanks, Bo. Thanks, guys.
Okay, guys, we're going to move on from that one because we're already over time, and we're going to go to just, this is really quick. We're almost done, guys. Couple of things just to point out. This is not high level stuff like what we just went through, but a couple of additional changes at TREC that I think are noteworthy. Number one, starting in February of this year, February 1 of this year, brokers and most sales agents will be required to complete at least 3 hours of contract-related coursework when they do their 18 hours of CE. So that's a new change you need to be aware of. Would hate you to do 18 hours and not have 3 of those be contract-related. So that's important. And then the 2 forms that will also be new in February that we didn't talk about is the buyer's termination notice and the short sale addendum. Nothing really to go over there, just kind of a heads up that we'll have new forms coming out there as well. Those are going to be, we believe they'll be approved by the commission in their February 16th meeting. So there may be a few new 2 new additional forms to go over as well. Seller Shield. Seller Shield is one of our sponsors. As I think most of you guys know, I'm the co-founder of Seller Shield and help run the company. I'm not going to do a pitch for Seller Shield, fortunately, because so many of you already use Seller Shield. This is kind of preaching to the choir. Many of the folks on this call were our first users in Seller Shield about 3+ years ago. So thank you. For using our product. Thank you for continuing to use our product. We now have over 100,000 agents and sellers that are in our platform. It's kind of hard for me to even say that. So I just want you to know, I very much appreciate those of you who have been with us since the beginning. Y'all have made it possible for us to do what we've done. We're now in 11 different states. We have deals with some of the biggest real estate platforms in real estate. We're available on ZipLogic. We're the exclusive provider of disclosure solutions on ZipLogic. We have a deal with Texas Realtors, California Association of Realtors, Pennsylvania Association of Realtors. We're with the biggest real estate brands in the country. We're doing great. And I mostly just wanted to say thank you guys because you guys were with us for the most part at the beginning. Please keep using us. I hope you find value in it. So that's it for Seller Shield. As I mentioned earlier, this PowerPoint is going to be available on the chat. You can download it. And we've got a little more information here on Seller Shield. We got a video. I'm not going to play it for you, but you can watch that if you download this presentation. I think that's it. Danii, I'm not sure if you're here. Were there any questions that you saw on the chat that you think we ought to cover as we wrap this up, or anything that you would like to add in terms of wrapping this up?
Yeah, I actually saw a really good one, Bo. It was in regards to the lease agreement. One of our viewers was asking if the buyer can be charged a termination fee if they originally wanted the lease to be terminated and then decide they're not going to move forward on the contract. Is there some compensation for the seller?
Great, good question, and thanks for catching that one. I missed that one. So the short answer is yes. The parties can negotiate fees regarding to leases as they see fit. Our particular form, I don't believe, specifically addresses that. I'm looking at it right now. I don't believe it does address that. But absolutely, the parties can negotiate the payment of termination fees or convenience fees or expenses regarding that. And the parties can negotiate who's going to share responsibility for that as they see fit. That is a really good question.
Right, I agree. Another concern that I saw was about the changes taking effect on April 1. What if we have these listing agreements in place prior? What if we have purchase agreements in place prior? Do we have to make some changes, some addendums to those?
Good, really good question. My understanding, I'm pretty sure I'm right about this. Somebody, Lisa or somebody check me on this. If you have a contract or a form executed prior to April 1, you can continue to use that executed form. If, however, you execute a form on April 1 or after, you must use the new form. Even if you maybe started the negotiation like on March 31st, but you didn't have a completed form and you're gonna finalize it on April 1 or after, you need to use the new form because it's mandatory on April 1 and after. And that's my understanding. Lisa, Danii, if you think I'm wrong on that, feel free to chime in.
I'm with you. I mean, if I think we got to tailor everything to execution date of a listing or a purchase agreement. And then there was some confusion about delivering of option money, as in, do we get a notification that the seller actually receives it? Not the title company, but how do we know if the seller gets the option? And if there's an extension to option, can we still get that money to the seller / listing agent? Or how does that work?
Great question. I'm going to take the first one because that's the easiest, and then I'm probably going to duck the other ones. But the first one is there a receipt? And I'm glad you caught that. Yeah, we got that question multiple times. There absolutely is a place in the contract, the 1-to-4 family contract, to receipt earnest money, and the escrow agent will receipt the earnest money. And that is on page 11 of 11. It's the first receipt provision in there, and you'll notice that it is the escrow agent that signs to acknowledge receipt. So the second, which by the way leads me to another good chat question I saw. The second question you ask is, will the buyer know when if the seller receives the option money? Probably. I mean, I can't imagine a good escrow agent isn't going to tell the buyer's agent about that, but they don't, according to our contract, they don't have to, because frankly, it really doesn't matter. Because once the buyer money gets to the escrow agent and the escrow agent receipts it on page 11 of 11, the buyer has their rights. So the truth of the matter is, it really doesn't matter if the seller goes and picks it up from the escrow agent. Which reminds me, another good question that I saw in the chat. Somebody said, who is the escrow agent? And their basic question was, is it the title company or is it the escrow officer? And the way I think about it is, escrow agent does not equate to escrow officer. That is not intended to be the same thing. Escrow agent is intended to be the party or the person, so it could be an entity, that is going to act as the escrow agent. And in Texas, 9 times out of 10, the escrow agent and title company are one and the same. They're typically the same. For instance, in San Antonio, Key Title Group is typically the escrow agent and the title company. In Lubbock, Joy Title is typically the escrow agent and the title company. Forgive me for doing a shameless plug for my title companies. I couldn't help myself. They're typically the same, one and the same. So the question was, should I make the check, if I'm a buyer, should I make the check payable to, for instance, in San Antonio, should it be made payable to Debbie Yates, who is an escrow officer, or should it be made to Key Title Group? The answer is, it should be made to Key Title Group, because Key Title Group is the escrow agent. Does that make sense?
Very much so. That also means that the extension to option is going to go exactly the same way to the title company, made out to the title company. We're getting a receipt from them, and that's all that we worry about, right?
I think that is how it should work. The 1 to 4 family doesn't envision additional option money. It does envision additional earnest money. So I think that that's how it should work, but it would be done through an addendum to the 1 to 4 family. But I agree with you, Danii. That's how it should work.
Okay, because yeah, I mean, I saw it in the chat and I looked over the changes, and I didn't notice that the paragraph, the option paragraph, has it included another verbiage for, hey, if we extend option to XYZ, the additional money is going somewhere else. I haven't seen that anywhere.
I think it's going to be done in the addenda, is what I think. I'm sorry. Yes, any
And the
addenda.
addendum, it stays in the 1903. Okay, perfect. Good. And I think we covered it all. I know you caught quite a few questions in the chat. I keep watching you. So good job on that.
Yeah, I'm going to answer one of them because it's for my company. Is there a mobile app for Seller Shield? There's not an app that you download, but our website is mobile friendly, so it's the same thing. And for sellers that want to fill out their disclosure notices by using our services, again, it is mobile, tablet friendly. One of the cool things about our disclosure solution is a seller can be walking around their house filling out their disclosure notice on their phone or their iPad or whatever mobile device they have. And we designed it that way on purpose so a seller wouldn't have to sit at their desk to do that. So technically not an app, but it works exactly the same way.
You know, Bo, I saw one more that I think we should clarify for everybody. The 3 days to deliver earnest an option is 3 days from execution date receiving at the title company or sent out via wire. What's the legal take on?
Great question. Receipt. It is receipt by and we all do this. I'm not picking on you, Danii, but it's technically the escrow agent. And again, in Texas, typically the escrow agent is the title company, but not always. So if you have a scenario where, like, sometimes people want a lawyer to be the escrow agent, but whatever, key title or whatever, a title company would be the one that's issuing the title policy. So the escrow agent is the one that deals with option money and earnest fee.
Okay, wonderful. Let me see if there's one more. Some had a question about oil and gas. Most concerned, nothing was said about oil and gas leases. If the seller is reserving mineral rights, why use?
Yeah, good question. We got that a lot, actually. I'm glad you said that. A lot of people say, well, you guys did an addendum for residential leases. You did an addendum for fixture leases, but you didn't do an addendum for mineral. That's a good observation, and it's absolutely true. And the reason is we're not competent to do an addenda for mineral leases. It's too complicated. There's no way we can condense it down into this. If you'll notice, our addendum for residential and fixture leases, they're 1 pages, and it's mostly just a bunch of disclaimers in here. There's not a whole lot to fill in. Right. There's no way that you could effectively do that for a mineral lease. So we just said that's beyond our ability. Frankly, it's beyond an agent's ability to use it. So we just said, to hell with it. We're not going to address it.
So if that issue arises, contact an attorney?
Absolutely.
Okay. Wonderful.
Okay, there was one question here. Now we've got it twice about the new requirements for your CE. The one that I referenced is part of your 18 hours. You all know, I assume you have to get 18 hours of CE. Part of the changes that TREC made is 3 of the 18 has to be on contracts. So make sure you're getting your 3 hours of contract education when you do your 18 hours. All right, Danii, unless you have anything else, we've gone over quite a bit. I think it's probably time to sign off. So, Danii, you got anything else?
No, we're good. Thank you for
Okay.
answering all those questions.
I want to thank a lot of folks who put this together. Our panelists, which is Lisa Munoz, Garret Brandt, Danii Sedillo. Thank you guys for participating. It's quite boring for one person to get up and talk for an hour and a half. So thank you guys for helping it out and making this more interesting. Couple of folks who put it all together: Miranda Minix, Tisha, who am I forgetting? Tori. You guys, thank you for putting all this together. Very much appreciate all your hard work on putting this information together. I'm probably forgetting people. I apologize if you were instrumental in putting this together, but those are the ones that are at the top of my mind. Thank you guys, and to all the attendees, thank you for attending. Very much appreciate you being here with us today, and I'm gonna sign off at this point. Hope everybody has a good day.